Start with a cough. Good afternoon, everyone. William Kirk, Washington Gun Law. We're going to give you some more live updates here on the Carmelo Anthony case. Things have taken an interesting turn, to say the least. As for those of you who are not aware, he was found guilty earlier today by the jury of murder. However, there is a little thing in Texas law where the defense can ask for the case to be submitted back to the jury to determine whether or not the crime was committed in what the Texas calls sudden passion. If the jury agrees that it was, then the jury, who is solely responsible for sentencing here, could reduce this down to a second degree felony. And his standard range of sentencing that looking at, originally looking at anywhere from 5 to 99 years, it goes down from 2 to 20. So is there a possibility that Carmelo Anthony could end up with 2 years on this case? A mere 2 years? Yes, there is. Do I think it's probable? I don't know. Is it more probable now than it was, say, 2 hours ago? It is, because the prosecutor agreed not to argue about that and let that go to the jury. The coverage that we've been watching from has been predominantly from NBC DFW Channel 5 down in Dallas, Texas. And I do want to give you the most recent update, which is from 16 minutes ago, which is the jury left the courtroom at 4:40 to be deliberation in the sentencing phase of the Carmelo Anthony murder trial. Carmelo has been found guilty of murder. Texas law says a murder conviction is punishable by 5 to 99 years in state prison. The defense argued during the sentencing phase of the trial that Carmelo committed the murder while under the influence of sudden passion. If jurors believe he committed the murder under sudden passion, the charge is reduced to a second degree felony, which lowers the punishment range from 2 to 20 years in prison. Court will be in recess until the jury reaches its verdict. So this judge, he's going to get this case done one way or the other. And candidly, this went a lot quicker. I did not know how they were going to handle this. So as it turns out, they don't put on a whole bunch of other testimony like you might in a sentencing phase of case. The only witness to testify was Carmelo's mother. And, she testified about how much she loved her boy. And, don't doubt any of that. But there was nothing about the actual incident itself that was offered in the way of additional testimony. So the record is what the record is as made at trial. Let me go back with the arguments, because I will tell you that both sides here are showing, I think, a little bit of emotional exhaustion. I think the prosecutor is happy that he's gotten the conviction, and because neither one of them really dug in on these issues. I'll give you an instant. Okay, so this is an update again from 45 minutes ago. Assistant District Attorney Dewey Mitchell spoke to the jury regarding the prosecution's position on the sudden passion argument. Something unique happened when we were in that big room, Mitchell said, referring to the courtroom. There was this sense of a bunch of people just wanting justice to be done. Y'all are the product of that. To me, it felt like a community. Okay. He spoke about how during trial on Thursday, witnesses described Carmelo as a son, a student, etc. He reminded the jury that Austin Metcalf was also a son, a brother, and the type of man who believed in people. He mentioned that Austin was full of testosterone, a big guy, but that didn't apply to Carmelo Anthony. I mean, we do have two late teenagers here. Mitchell told the jury that the defense will talk about Carmelo's age in their arguments, and he urged them to consider the victim's age as well. Nothing you do with your verdict, no matter what it is, nothing will take more from Carmelo and his family than he took from the Metcalfs, Mitchell said. Plausible argument. He explained that Austin will never get to meet the love of his life, hold his graduation plaque, or have children. The jury was shown photos from the track meet showing coaches performing CPR on Austin the day of the stabbing. Obviously, family members of the Metcalfs were crying. Mitchell, the prosecuting attorney, said, "This is not about vengeance, but it's not about leniency either. In Collin County, that's the price of taking a life." There are going to be bleachers at stadiums in Collin County where parents are going to watch their kids play. One of the reasons we're in the community we live in is because we feel safe. By giving a fair justice verdict, my prayer is that we will find healing. Okay. So you can see, again, very plausible, effective arguments, but the prosecution is not just like beating on the table here, talking about how this is completely unjust. I mean, they're really just saying it's up to you. Okay. Then the defense attorney. And I get a lot of you are being real critical of the defense attorney, and that's fine. You're entitled to criticize. Again, I this may be how it is typically done in these situations here. Okay, so I'm making no commentary on the attorneys here, other than this was a very tough case, especially if you're the defense attorneys. Mike Howard was the attorney who spoke there. I cannot, will not stand here and say what the right verdict is. Okay. I stood here in front of many juries in my career, some big, some small, and I've had this conversation many times. It's never easy for me. I couldn't begin to tell you what the right thing to do is in this moment. You will know that in your hearts. That's the defense attorney here. I mean, it's again, I'm not being critical of the arguments, but if you're looking for these vehement, fierce arguments for one side or the other, you're not getting it here in this. Anyone who stands up here and tells you puts numbers clearly does anyone who stands up here and tells you put a number clearly doesn't understand how hard your job is, referring to the jury's role and how they're going to determine sentence. I can only ask you to consider both sides. Follow your heart and follow the law. All right. Then he went into an explanation of the sudden passion defense. Uh, Apparently, there is a state approved video that a jury will be instructed on about the sudden passion defense. Decisions made in the heat of the moment are different than decisions that come after reflection. That's how the defense attorney explained it. So when something happens, Austin Hunter, the kids under that tent, when that happens, and you believe that Carmelo felt terror in that moment, such that it rendered his mind incapable, that he didn't have time for cool reflection, passion applies. You do not have to be sure of sudden passion. Okay. So I believe the jury does have to be sure of it. I mean, they have to be unanimous for sure. So, anyways, there's more here, but this case has gone back to the jury to consider that. We don't have any other updates. The last update was 21 minutes ago, where the jury had now been sent back for deliberations. Let's talk about this sudden passion argument here, because I do want, if you're taking a look at the trial record here, okay, there is arguments, evidence both for and against it. The arguments for it is number one, you have a young, immature, emotionally unregulated, pubescent male. Okay, you can play all those games. Okay, but there is some truth to that. Okay. Secondly, when you take a look at how fast this situation developed and deteriorated and quite rapidly, there is a plausible argument to be made. I am not saying a winning argument. I am not saying even a convincing argument. Is there an argument that can be made with a straight face? Yes, there is. Okay. Now, there is evidence that cuts against it, however, as well. Okay. For example, uh, there was plenty of opportunity to leave. It seemed appropriate that perhaps that would have been the correct thing for him to do based upon the correct customs, as it was for these track meets. But the thing that really concerned me was the putting his hand in the bag and basically daring Metcalf to touch him, almost challenging him to do it. And there was almost like, I wouldn't call it premeditated, because I don't think the kid walked into the stadium premeditated to do something like this, but it was something that was thought through a little bit in that moment. And, is it a lot of time to reflect on it? No, but that's the same. Now, again, had their evidence come out different, that, Carmelo was surrounded by a bunch of kids who were all threatening to beat his ass and things like that, then the argument gets a little stronger. So this is the kind of stuff that I would hope the jury is talking about. And I say I hope, because I think those are the operative facts. Those are going to be the determinative factors as to whether or not they actually find sudden passion. Now, again, they could find sudden passion and still sentence the kid to 15 years, 20 years maximum. And I recognize that nobody is really going to be happy with this verdict. There will literally be hardly anybody happy, except if we got like 99 years. And then I know a whole segment of the viewers in the last video would be very, very happy. There were a lot of people asking for the death penalty. Let's remind everyone that the death penalty was never in play here. The state of Texas is serious about the death penalty. I promised on the last video I was going to explain this. Everyone thinks Texas leads the universe in executions, or leads the United States. They usually do, but this year, Texas has executed 5 people, puts them on the silver medal platform. But the state of Florida has already executed 19. So in the state of Florida, if you go down there with the intent to kill, understand that they will kill you back. So they're serious about that. Um, okay, I'm going to see if we got another update because and here's the thing, I got a hard stop at the top of the hour, actually a little bit before the top of the hour. I don't know how long the jury is going to deliberate on. This might be a little bit more difficult of a decision than the ultimate guilt or innocence, at least based upon the way the evidence came out. I'm going to ask all of you right now down in the comment section for all of you who are tuned in. One, thank you very much. For those of you who are joining late, let me get you up to speed real quick. What has happened is this case has been resubmitted to the jury under the sudden passion defense, which would allow a jury to find if the crime was committed in a fit of rage and sudden passion without the ability to cool off. That's kind of my cliff note version of it. They could find this to be a lower degree of crime and actually a second degree felony, and then the sentencing range would go from 2 to 20. So, is there a possibility that Austin Metcalf could be sentenced to a mere 24 months in prison? It is a possibility. The probability, I don't know. Well, here's what I want to hear from you guys. I want to hear number one, would you find this as a crime of sudden passion? Yes or no? And then afterwards, throw the number of years that you would give if you were on the jury right now deliberating it. And I want you to base this on the evidence that came out in the case. Okay. Now, I know some of you have been throwing a lot of shade on the Anthony family and money they raised and what they may or may have not done with that money. And you may be all right. Okay, y'all may be. I'm not getting into it because that's not what we do here at Washington Gun Law. We don't cover that stuff. I don't want that to be used in your calculation, though, as to what the kid's punishment should be. Okay, so we got a lot of people jumping in right away. No, 99 years. No, 99 years. I got no 25 years. 99, 25. We got 60. Got 50. So those 60s, 50s are going to be no's. 76, Austin's expected lifespan. Okay, that's one way of calculating it. 45 years in Texas, which according to, I'm going to put that one up if I can real quick. I appreciate it. Amy Nichols, thank you, Amy Nichols. Thanks for you tuning in. Oh, that's the wrong one. Oh, shoot. Yeah, no, wait. Did I get the right one? No, it's F. Stewart right there. Life, aka 45 years in Texas. That may be considered a life sentence. I think in Washington State, it's anything beyond 13 years, 4 months. It's considered a life sentence. It's not a particularly high number. 25 to life, 50 years at least, or okay. No, 50 years with no parole. Young man's lifespan. Anything less than 25 years. I like, this is one. Let's see if I can find it. They're coming in so quick. Yeah, I'm gonna throw that one up there. This is from Warrior 21 Poet. Anything less than 25 years is BS. I think. Well, I'm not going to really tell you what I think, but I will say that I kind of agree with that statement right there. I just don't see this as a crime of sudden passion. I just don't. I think there's enough there to make that questionable. I think I think the 99 years, when you consider the age of the defendant here and things like that, I don't know. It doesn't really matter what I think. You guys keep telling me what you think. For those of you just tuning in, we got a new update. Here we go. Let's see. Ow. Okay, well, it's just courtroom sketches. Courtroom sketches are the new updates. So nice to see that there's still a market somewhere for courtroom sketch artists. They used to be a big deal. There's still a big deal in federal court because federal court has a standing rule that there's never cameras in a federal courtroom, period. End of story. It doesn't happen. You don't even get to watch United States Supreme Court arguments live by video, which I find to be odd. I understand in a trial courtroom where things can get crazy. There's a reason they make you go through metal detectors when you go into those buildings. I understand that. But anyways, so I don't need to share with you courtroom sketches. None of it matters anyways. We are waiting the jury to return a final verdict as to whether or not they determine this to be a crime of sudden passion. If so, they will have to determine a sentencing range between 2 and 20 years. If the jury does not find that this is a crime of sudden passion, they will have to find a appropriate sentence in the range of 5 to 99 years. An amazing 94-year range. Fascinating how they do it in Texas. So that's where we are at now. Any of you have any questions related to trial procedures or appellate procedures or things like that? Go ahead and throw them down in the description box. I'll try to get some of your questions answered as we await this. I don't know if the jury may be hung up on this for a while, and I got about 15, 20 more minutes. I get to stay online, then I got to go get ready for a pre-recorded interview that we're doing for a video series that I can't talk about right now, but it's going to be super cool. Really, really, really cool. And I'll just say I want to thank the Trump administration for the access that they have shown us to various individuals. I'll just leave it at that. For those of you who are, again, screaming for the death penalty, I get it. I get it. But let's remind you that it is not in play here. This was never charged as a capital murder. And so the state of Texas, which does take the death penalty quite seriously, was never seeking that whatsoever. So interesting that you guys bring up the capital punishment. There is a lot of stuff kicking around on X about the state of Idaho passing a law that says that you can use the death penalty for those convicted of very serious child sexual offenses. And they make it seem like that law just got passed this year and just signed by the governor. It actually got passed a year ago. But there's a couple of interesting cases on the United States Supreme Court where that issue has actually already been determined in some context. And it was a 5-4 decision that says that's against the Eighth Amendment. But the interesting thing is 3 of the 4 judges that were in the dissent are still on the bench, and all 5 of the justices that voted are all retired. So I think if that issue ever were brought before this particular United States Supreme Court, and they were willing to take it, 2 big things, I think that the case law may change on that. That may be deemed legally permissible. Until we actually have a state that tries to implement that penalty for a person who's been convicted of those crimes, we don't have grounds for an appeal on it. So we'll see. It will happen at some point, unfortunately, though. And when I say unfortunately, it means that somebody has committed such a heinous offense that we're actually having to talk about those types of penalties. So, anyways, all right. Yeah, he is in custody now. Let me explain to you how this works. No matter what, the kid's going to prison today. I mean, well, he's technically probably sit in the county jail for a couple days and then be transported to whatever prison he will be sent to. Even pending an appeal, there's not going to be an appeal bond issued on this case. And even if there was, it would be such that family can't afford it. You're spending a ton of money for what might be temporary freedom. So the bail, what we would call in this case is the bail's been revoked or the bond's been canceled. I believe they use the term extinguished in Texas, which means the bond is now extinguished. He is not out on bond. So he is in custody at this time. At this point, he's not sitting with his family in the hallway of the courthouse or in the courtroom during recesses and stuff. He's being taken back into the secure parts of the courtroom there where you keep the inmates. And he will be booked once the proceedings are done. He will be booked into that county jail tonight. And from there, he will be transported to wherever he's going to go. The appeals will soon start afterwards. There will be appeals. There always is. You get one appeal as a matter of right. So they're absolutely positively going to appeal. Do they have things to appeal? I would really, really, really have to take a look at the trial record, dive into it to see where there could be possible areas of appeal. 3 areas that we commonly see criminal appeals on or appeals of criminal convictions is in jury selection, in jury instructions, and then in improper questions that were admitted or exhibits admitted that should have been excluded. Those are the kind of common areas that we see criminal appeals. However, there's a thing known as the harmless error doctrine, and the harmless error doctrine basically says, yeah, you're right. There was 18 pieces of evidence that showed you're guilty, and right, exhibit number 18 should have been excluded. It was improperly obtained or wasn't properly uh, authenticated before we admitted it into evidence, and we let it in. So you're right. But the problem is that there's 17 other pieces of evidence that also show the same thing, and you're guilty, and so therefore it's harmless error. So you see a lot of appeals where the appellate court would be like, "Yeah, you're right. We shouldn't have let that piece of evidence come in, but it doesn't really matter, so you're going to stay in prison anyways." The one area that you really don't get harmless error out of is in jury instructions. Okay. And that's why they use pattern jury instructions, things that the state Supreme Court and or Bar Association has already said are appropriate and a correct statement of the law. If you're the judge, you stick to the pattern jury instructions. You ain't ever going to get flipped on appeal on a jury instruction. Why? Because you gave the approved jury instruction, so you're good. Okay, well, I appreciate this is someone who's been geeking out with us for the last couple of days, and I appreciate this. I have said this many times when talking about the criticism of defense counsel. This is a slight play on what I've been saying. That may or may not be true. I don't need to repeat it, but there it is for all of you. But again, for those that are being critical of the defense attorney and their ability, I don't know him personally. I'm not going to pass judgment on it. I'm not going to armchair quarterback that. But I have said time and time and time again, you can't make chicken salad out of chicken shit. Candidly, listening to the evidence, and especially all of the young people's testimony, we didn't mention any of their names, but there was probably, what, 10, 12 teenage witnesses, and they all told a remarkably similar story. There were tiny little differences on some nuanced things and things like that, but the big picture, it all really, really fit together well. That's a pretty good case when you're the prosecutor. If all the pieces of the puzzle seem to be just falling into place, that's a good day for you. So, okay. I don't have any other updates, and I'm just going to kill time here for a few minutes until obviously I got to get rolling. I would love to get at least a verdict on that to see, could I see the jury having a very long discussion about this? I could. Um, I don't know how long the judge will let them go tonight. Um, the thing about it is, if you're the jury, is if you reach that verdict tonight, you get to go home tonight. You will be excused from jury duty, and your obligation's done. You can go home. I don't know if certain people want to go home, depending on some of the activity that we've seen outside the courtroom. I might want to go somewhere else. If they can't reach a verdict on that tonight, they're going to be sequestered again tonight. I am no doubt they sequestered them last night. They'll sequester them again, which means you're probably staying at some crappy Motel 6. Your TV is unplugged, and you're going to have, like, room service dining. That's probably what's going to happen. So jurors, that will motivate them sometimes. That will motivate them sometimes. I always debated about whether I wanted to talk to jurors or not after trials, even cases I won, because there were times where you would learn a lot about what you need to work on as a trial lawyer, or what was wrong with that case, or what was really right about that case. And then a lot of other times you'd completely lose faith in the jury system as a whole. You'd be like, oh my God, I can't believe these people sat on this jury. And you'd want to just, punch yourself in the mouth for allowing them to sit there. So that's, and what I think that with these with these jurors, what they'll probably do once they render the verdict, if the Collin County is smart, they will have some kind of an police escort off the property and get them into a certain location where, because unfortunately this is a very emotionally charged incident. We've been looking at live feeds outside the courthouse today. Things have remained relatively nonviolent. I wouldn't say calm, however. And this is a horrifically emotionally charged thing that a lot of people, unfortunately, when we get emotion involved, any common sense, any logic, any connection to reality in many ways just goes out the window. So that's why I've always been trying to give it to you guys just straight, so that you can figure out, what does it mean to you? And if you want to get emotionally charged about it, great, do it. Um, all right. Yeah, no sentence yet for those of you just showing up. Case has been resubmitted back to the jury under the, oh my God, why am I going to draw a blank on it now? Sudden passion defense, right? That's what it is. The sudden passion defense. Both the prosecuting attorney and the defense counsel was able to argue as to why the jury should or should not consider that. I will tell you that both their arguments were extremely tame, thoughtful, not particularly aggressive, not a lot of advocacy from either side. Uh, It could be possible that they had made that agreement off record. I have been in trials before with attorneys that I trusted, where off the record we agreed, like, hey, I tell you what, I won't do this if you agree not to do that. And again, as long as it's not affecting the rights of your clients, and you just want to smooth things out, maybe you've had a very adversarial trial and the jury's getting pissed at both sides. You don't want that. So it's like, maybe you go out in the hallway and you agree, like, hey, let's tone it. Let's, you and I agree to tone it down a little bit, and so that the jury doesn't hate both of us. Maybe they only hate one of us by the time this is all done. That is a possibility. I don't know what the relationship is between defense counsel and prosecutor and thing like that. And sometimes when emotion is really, really running high in a courtroom, it's hard to do any of that anyways. Um, There's a good, interesting comment here. This is from Bob McBride. I don't see sudden passion given they went murder and not manslaughter. That is as plausible as any other theory. I will say that. I think you could still find sudden passion and still consider this to be murder. I've looked at the jury instructions. I don't want to bore you guys with all of the jury instructions here today because at this point, the verdict's already been rendered. Um, but no, it's not an, it's not a ridiculous point, and we're going to find out here. Why wasn't sudden passion argued before? Good question. Heterodox 3487, great name too. Um, well, as near as I could tell, is that this is actually the way it works. That sudden passion does not get argued unless there has been a conviction, and then it is argued as a sentencing mitigator. This is how the state of Texas does it. And I think the prosecutor could have objected, and then probably would have been a big, long, drawn out argument about why it should or should not be put back to the jury. In this case, the prosecutor agreed to allow it in. He did not agree to have the jury, to stipulate for the jury to find it. No, he argued against it, and the defense attorney argued for it. So that's why it was. And you bring up another good point, which is if in fact you are the defense attorney, and that is plan B if you lose, it would be really, really wise during the course of your cross examination of state's witnesses, and then again of your direct examination of your witnesses, to elicit evidence that you could then refer back to during the arguments on sudden passion. So whether or not that was done, I don't know, because why? I haven't been able to read the live transcripts. I've been relying on an NBC affiliate down in Dallas Fort Worth, where I think's done a very good job of covering this, but I'm getting summations of things. We are getting some quotations out of the courtroom, but it is, uh, bits and pieces without the context. So, but I would say that a competent defense attorney, if you're in the back of your head going, man, if we lose this, we're going to have to argue sudden passion. You would be very, very wise to elicit that testimony so that when it's time to argue it, you're like, you can remember when witness so and so said blah blah blah, right? And then this witness backed them up, and remember what that witness said about this and this and this. And anytime you are appealing to emotion, but you can attach it to an actual verifiable fact, becomes a little less emotional at that point, a little easier to digest too. All right. Here's one. American Bald Guy. Great name. 7 to 20 is my prediction. All right. Is that hetero bald guy? Well, no, that's not the one. No, it's this one right here. It's heterodox 3487. 7 to 20 is my prediction. Okay, cool. All right. Listen, we are at 3:27 West Coast time. I have to check out here in a little bit, and it's quite possible that this is going to be the last live cast we do on this, because if the jury comes back, and they've been out for 43 minutes now, not an astronomically long time. If the jury comes back later this evening, I don't know if I'll go back live tonight. Maybe. I don't know how long they're going to deliberate. Anything beyond that, I would probably just do a pre-record, throw it back on the channel in the normal format. But I do want to thank all of you who were kind enough to tune in on a lot of these live things. A lot of these were done on a fly. And the only reason we actually decided to do them, and we could thank Mrs. Gunlaw for this, is that she loves this crime drama stuff. She follows all these cases. And she was just asking me tons of questions about this case. Why is this? Why come the prosecutor this? Why is the defense attorney that? And I could give her pretty good answers, not specifics to that particular courthouse and that jurisdiction, but why in general, and the way a trial is structured from a constitutional standpoint, why things happen the way they do. And then she started saying, well, you really need to start doing live updates on this. And I was like, I don't know. And she convinced me to do it. So if you guys enjoyed this, thank you very much. But thank Mrs. Gunlaw, because she was the motivation for this. And as y'all know, if you just do what your wife asks, things usually do work a little bit better. Uh, Pretty annoyed. Hey, R Speed, this one right here. Pretty annoyed you didn't answer my super. I'm going to try to find it real quick. I don't want to leave you hanging like that. You got to remember, sometimes the comments come in and they're so fast, and I'm running this off of StreamYard. And so what happens is by the time I look back down, because like right now, I'm not even looking at the camera, it'll just blaze right by me. It'll get so high on the list. I'm sorry, brother. I'm sorry. So if you want to repose the question, you don't have to pay for a super. Just repose the question. I want to hear your question. I want to get you taken care of, and I appreciate you showing some love to Washington gun law. Bats versus Kentucky. Batson. Yes, Batson versus Kentucky. Thank you. Oops, right here. Yeah, you bet, brother. Okay, so this is the question he posed. It's actually Batson versus Kentucky. Appeal validity bar for defense. Yes. Is that grounds for an appeal? Yes. If you believe that there were Batson challenges that should have been sustained and were overruled, you can appeal that. The appellate court would have to obviously determine, based upon the trial record, whether or not the court abused its discretion and, in this case, would have been overruling the objections, or they followed the law. If they follow the law, you lose the appeal. If not, then the court could find in favor of, in this case, the defendant. However, the court would also need to find that that had such a taint to the entire process, that there was literally it polluted the entire process to such a degree that there is really no faith in the ultimate verdict. Then they could order a new trial. It would not be like, okay, Mr. Anthony, we are vacating the conviction and you are a free man, never to be, never to be charged again. That is not on the table. As a matter of fact, there is no appeal that I could think of on this case. This is a good question. I appreciate you asking it. Thanks for asking again. There is no appeal on this case that could literally result in charges being dismissed and Mr. Anthony being set free, never to be charged again. There are appeals that could be made that, if successful, would vacate the verdict and remand the case back down to the Collin County Court for a new trial. That's what would happen. Most defense attorneys, prosecutors won't want to talk to you about this, but most defense attorneys will tell you that having to defend a case a second time on a retrial is even more difficult than trying to defend it the first time. So, I'm sorry I missed your question. It was a great question. I hope that answers it for you. If you got a follow up, go ahead and let me know. But no, I was not trying to blow you off. It's just sometimes and sometimes I'll ask these questions and then I get like 30 comments just come in right away, and I miss it. So I apologize for that. This is an interesting one for Mr. Green here. Mr. Green, 1988. Hope the victim's family sues for all those hate donations. Again, whether or not there is a large war chest of donations, I'm not going to get into that. Does the Metcalf family have a wrongful death claim against the Anthonys? They have a wrongful death claim against Karmelo Anthony, for sure. Does that allow them to get to all the family assets, and do those family assets even exist anymore? Those are all questions. But yeah, candidly, Carmelo Anthony could have been found not guilty and still been subject to a civil suit, right? Ask OJ. Well, you can't ask him anymore because he's gone now. But OJ Simpson was acquitted on a criminal case, double count of murder, and found liable when the Goldman family sued him. So, yeah, that can absolutely positively happen. Will it? I don't know. Someone's saying $600,000. I have seen that. VSO Gun Channel. Thanks for checking in. Appreciate it. Love the work you're doing too, by the way. Um, but yeah, that is a number that I have heard, $600,000. Now, I have also heard that typically in pairing with and yet he went out and got a public defender. My homework tells me that this is a private attorney, pretty well-known private attorney in the Dallas-Fort Worth area, and I'm assuming did not do this case pro bono. What the legal fees were, I don't know. And honestly, even if I did know what the legal fees were, I wouldn't tell you, because that's for them to tell you. It's just none of my business. All right. Another interesting question or comment. Eric Godden 5371. Go for platform roles. Do not allow fundraisers to defend violent acts. That is, as we know, when it comes to crowd surfing things, it would appear that there are rules for me and rules for thee. Okay. As we know, if you are trying to raise money for conservative causes, that can be extremely difficult. And if you're raising money for other causes, that can be quite easy. And that is many of the what I like to call the privatization of censorship, which we won't get into today. Um, Carmelo, this is Mr. Hamlet. Thanks for checking in. Carmelo Anthony's lead lawyer was Mike Howard, private, experienced criminal defense attorney hired by the family. That's what my research showed as well. And I know what I would charge for a case like this. So if they really did raise $600,000, I can promise you they got a lot less than that now. A lot less than that. So, anyways, all right. Right here, gonna throw this one up real quick. Wouldn't a civil suit be able to extend to family because he was a minor at the time? If he was a minor at the time, that is a good question. Was he 17 at the time of the incident and 18 now? That is a possibility. Here's how else. Let's say the family bought him the knife or something like that. So, excellent question, and it could. And the truth of the matter is if you were gonna be the plaintiff's lawyer on that, you don't even want to take the case unless you know you can get to the family because you know the kid doesn't have two nickels to rub together. So you can get a $5 million judgment against him, but he's going to be spending the next how many years of his life in prison, and after that, he's a convicted felon. So it's not like you're going to collect on it 20 years from now when he finishes medical school and he's running a surgical center at the University of Houston Hospital or something. I just I'm not trying to be sarcastic here, but yeah, you wouldn't want to actually try to take on a civil suit unless you know you got a deep pocket somewhere where you can get your money out of it. That's the only reason to sue. It's horrible, especially in wrongful death cases, because you basically take a human life and you argue about what a dollar value is of that human life, and it's disgusting. And yet, that's exactly the way it does. And all the money in the world doesn't bring the person back. And it's just it's terrible. But very very good question, and I appreciate that question. I'm going to go back through here real quick. I want to make sure I didn't miss a couple of other you that were really kind and donated here to Washington Gun Law. I appreciate all of you who tuned in for all of these. I don't know if we're going to get to do another one. I'm going to do one more check and see. Oh, we got some updates. Here we go. Here we go. Well, this appears to be a recap. Yeah, these all appear to be recaps. The most recent one 6 minutes ago, so 5:29 Central Time. During his remarks during sentencing, prosecutor Bill Werski told the jury that sudden passion, aka heat of passion, means passion directly caused by and rising out of provocation by the individual killed. During the trial, prosecutor said it was the defendant, Carmelo Anthony, who was the one provoking, and that sudden passion doesn't fit the bill here, and the defense got it wrong. It's a plausible argument, a very good one, actually. The defense asked to include sudden passion in the jury's sentencing documents, and the state agreed. Okay. The jury will now answer unanimously on the verdict sheet. While that finding Carmelo Anthony guilty of murder, they also unanimously find whether he did or did not cause the death of Austin Metcalf under the immediate influence of sudden passion arising from an adequate cause. Remember that. It is not just that he was under the immediate influence of sudden passion. It has to have arisen from an adequate cause. And we can get into that, but that's what's going on. Um, and then, of course, it talks about if they find that it was committed under sudden passion, they get to adjust downward, and we're looking at 2 to 20 years. That is the last update. That is officially from 8 minutes ago, roughly 9 minutes ago now. So listen, at this point, Washington gun law's got to ready for my next thing. I got a pre-recorded interview to do this evening with a guest that I'm hopeful will be able to turn this into a regular thing, but they're busy people, so we'll see how it goes. All right, let me check one other thing here real quick. All right, good, got that. I wanted to make sure I didn't miss that one. Gonna check the comments one more time, guys and gals, especially the gals who tune in. I appreciate that because, well, I look at my analytics. I know I know what my audience looks like. It's much like any of you guys. If any of you guys are Rush fans, who are, by the way, back out on tour right now and I'm hearing really good things. I Rush 4 times live, but, there's not a single chick in the whole building when you go to a Rush concert. That's kinda like what a Washington Gun Law audience is too. So, anyways, all right, listen. Yeah, yeah, this is the Washington Gun Law audience right there for you. That is an accurate description, but listen, I appreciate all of you who've been geeking out with Washington Gun Law, not only on this live stuff, but on all the other stuff that we cover. I gotta get running. I gotta get ready for my next thing. All of you stay safe. Now, if the jury takes a whole lot of time, and by what would be 7 p.m. Central Time, when I'm done with my other thing, they're still kicking around, I don't know. I might go back online again. In my pre-drinking days, I would have been like, "Yeah, I'll go get a couple of bourbons in me and I'll turn the camera back on." But I retired from that about 10 minutes ago. So, anyways, thanks so much for tuning in, everyone. And if there's any more live updates that are going to mean anything, we'll let you know. Once again, just to wrap it up, if you're catching at the very end, jury is taking the case again to determine if there will be sudden passion. It would allow them to drop the standard range from 5 to 99 years down to 2 to 20. It is in the hands of the jury. It appears that the judge wants them to deliberate well into the evening. We'll see if anything happens. I want all of you to stay safe out there. Look out for each other, and we'll talk to you later. Thanks so much.